Good evening and welcome to Closing Arguments. I'm Michael Ayala in tonight for Vinnie Politan, and we begin in Minnesota, where jury selection is underway in the trial of former Minnesota police officer Kim Potter. Now, Potter is accused of killing 20-year-old Daunte Wright after pulling out a gun instead of a taser during a traffic stop. Today, 4 jurors were selected, so I want to bring in now Court TV legal correspondent Chanley Painter, who has been keeping a close eye on the proceedings. All right, Chanley, great to see you. Get us caught up on where we stand after day 1 of jury selection.
A lot of progress made today on day 1 for jury selection. About 200 questionnaires were sent out before this a couple of months ago. Those prospective jurors now showing up. They're brought in by groups of around 6 or 7. The judge gives them some instructions and general questions, and then one by one, Michael, they're brought in and being questioned by the judge, the defense, the prosecution. One of the final prospective jurors, I was going to say witnesses, prospective jurors who made it through was juror number 11. Late this afternoon, she was seated. We have a closer look at her. She's a single working person. She told this court that she has a female friend who passed away from a fatal stabbing, and the suspect was arrested and went to prison, but she didn't interact with police. That's one of the common questions during this is how have you interacted with police? Was it a positive experience? Do you think police can be fair? That line of questioning. And she has never served on a jury. So those are some of the general things that she told this court. And again, she made it through to the next round. But overall, if we take a step back and look at the day as a whole, 11 prospective jurors were questioned and 4 of the 11 were seated today. The state has used only 1 of its 3 peremptory challenges so far. The defense has used 1 of the 5 peremptory challenges it has moving forward in this jury selection process. And late this evening, the court actually released the official demographics of those 4 jurors who have been seated to hear this case against Kim Potter. So we know there's a white male in his 50s, a white woman in her 60s, a white male in his 20s, and then an Asian woman in her 40s. And that was juror number 11 I just told you about. Now, there were many, as you can imagine, dismissed for cause today for various reasons. One of those was juror number 5. Let's take a listen.
You have a young black male victim, right? And you told us before, honestly, before you got the jury summons, understandably, you had read a lot about him. So you know the things that the media reports he's been alleged to have done, right?
Correct.
And he's not on trial here for those things. You believe that he's gotten away with some things. He hasn't been held accountable for those things.
Correct.
Yeah. You have a situation where he allegedly wasn't cooperating with a police officer, right?
Correct.
And you think that's wrong, and that's part of why you have a negative view of him, right?
Can I comment more? Or?
Sure, absolutely. Yeah.
I think if he would have listened to the directions, he would still be with us.
So that was a father of 2, hockey coach. He basically had a negative view of Daunte Wright, saying that if he just complied, he wouldn't have been shot that day, and that he believed Black Lives Matter was a communist Marxist group, Michael, so he was dismissed for cause.
Yeah, he was an interesting guy. I enjoyed listening to some of the things he had to say. So ultimately not making it on, so that made sense to me. Now, one of the things I noticed about this trial, Chanley, is that it's in the same courtroom as the Derek Chauvin trial. And I've also seen some familiar faces, one we saw right there. What similarities are you seeing between this trial and the Chauvin trial?
Yeah, this is the same courthouse, the same courtroom as the Derek Chauvin murder trial. And like you, we're seeing some familiar faces, including the prosecutor in this case. That's the Assistant Attorney General Matthew Frank, and he's been a prosecutor for 21 years. He was assigned to this case in May by the Attorney General of Minnesota and he's head over the criminal division at the Attorney General's office. And then next to him in that split screen, we have the defense attorney, Earl Gray, and he is familiar because he represents former Officer Thomas Lane, who's also charged in the death of George Floyd with an upcoming trial. But he's one of those defense lawyers that really is a go-to for that Minnesota Police and Peace Officers Association, that when an officer uses force or involves shooting, these are the defense attorneys who specialize in representing police officers.
Yeah, now, the potential jurors were sent questionnaires. There's another similarity between the Chauvin case as well. So what do we know about those questionnaires?
Yeah, these questionnaires are very similar to the Derek Chauvin questionnaire sent out, and it's 17 pages long. It has different sections about the background of the prospective juror, their views on law enforcement, their views on movements, and of course policing issues within the Minneapolis area. But let's take a look at one of the pages there, because it's interesting. These jurors can rate from 1 to 5 favorable, unfavorable views with their relations with law enforcement. Some of those include whether or not they agreed to defund the police, or that the criminal justice system is biased against black people, or do they trust the police? And we hear the attorneys today and the judge following up on these responses. If there's a very unfavorable viewpoint, the judge may ask about it, or the defense attorney may ask about it. They want to elicit a little bit more details from these prospective jurors to see if they can really be a fair and impartial juror.
Now, what trends were you able to make out with these prospective jurors? I actually was surprised, Chanley, to hear how many potential jurors had negative feelings toward Officer Potter. I didn't expect that. So remind us, what you saw today in terms of any trends in the answers.
Yeah, that's a good point, because a lot of people believe this was a tragic accident, but yet almost every prospective juror who entered the courtroom today had put on their form they had a negative or somewhat negative view of the defendant, Kim Potter, in this case. There was one particular juror, number 9, who virtually told the defense attorney, Michael, do not pick me because I have so much bias against your client, Kim Potter. And of course, that juror was dismissed for cause. And then one that was seated, juror number 6, said she had negative views of both Potter and Wright, and some of them did say that, given the circumstances, but other things involved handguns. That's a big issue in this case. They were asked about anti-gun, pro-gun, tasers, their knowledge of a taser or any training in that area, and of course just generally what they knew about the case, and if they could set that aside and be a fair and impartial juror.
Chanley, I don't know if it was number 9. I don't know if you remember which juror, but I remember hearing one juror said he wanted to be on the jury because he wanted to see how an officer gets convicted. Which I was amazed. I mean, I couldn't tell if he really meant it or if he was just trying to get off the jury. It was just interesting. But anyway, remind us of the charges that Potter is facing.
This is really important, and this was a battle in court documents, Michael, because the defense does not believe that Potter should face this first-degree manslaughter charge that was ultimately overruled by the judge. But here's what this charge does say. It's count 1 of this amended complaint. This was added later when the Attorney General's office took over this case, but it's first-degree manslaughter, so the prosecution has to prove that a person died, that the defendant caused that death, and then while the defendant caused that death while committing a misdemeanor or gross misdemeanor offense, and that the defendant committed the misdemeanor or gross misdemeanor with such force or violence that death or great bodily harm to another person was reasonably foreseeable. So for count 1, that standard, that's a reckless state of mind, Michael, and they're contending that her choice, Potter's choice of using force, was reckless in that situation, and she could be sentenced up to 8.5 years if convicted. Of course, they're asking for aggravated sentencing, which could be up to even 15 years if the judge or jury agrees to that. But real quick, let's look at the second-degree manslaughter, the original charge in this case, and that basically just proved the death of Daunte Wright and that the defendant caused that death by culpable negligence, whereby the defendant created this unreasonable risk and consciously took a chance of causing death or great bodily harm when she chose to use force in that incident, Michael. So different mental states here. That's what this case is going to come down to.
Yeah, it's going to ultimately come down to that mental state. And also, I think it's just going to be a battle of the experts. This is one of those that both sides are going to bring in experts, and it's going to hinge on their particular testimony. All right, Chanley Pinter, thank you so much for that report. Always appreciate your reporting. We'll talk to you again a little bit later. But right now, I want to bring in the think tank joining us tonight in St. Paul, Minnesota, criminal defense attorney Jack Rice. In Seattle, Washington, trial attorney Ann Bremner. And in Atlanta, Georgia, criminal defense attorney, former federal prosecutor, and law professor at Texas Southern University, Michael Sterling. Thanks, guys, for being with me tonight. And I want to start with you, Jack, because you are, of course, in Minnesota. And I want you to give us a primer on the process of jury selection in Minnesota. We're seeing here a case where panels are brought in and then they're questioned individually. And one of the interesting things that I find here is that then the strikes are being taken as they go along, not as a group, which I find very interesting. Tell me about it.
Yeah, Michael, absolutely. I mean, what we usually see in Minnesota is you usually see what you see around the country where you're going to pick a jury as a group. The benefit to something like that is you get to ask a question and then bounce that around the jury, ideally getting them to talk to one another. But the best part of it is when you're done, when it's all over, then you start striking people. you start saying, I don't want this juror, I don't want that juror. The problem with doing these one at a time is you have to make a decision right then. So what you're doing is you're guessing how good is this juror or how bad is this juror, and more importantly, are they going to be better or worse than what's coming down the pike? So you're having to struggle with that piece too. But this is, like you said earlier, very similar to what we've seen in the Chauvin trial. I've seen this in some crim sex cases. I've seen this in some murder cases too. And I've been in front of Judge Chu myself, so I'm not particularly shocked by that.
Oh, actually, tell us about Judge Chu. I was going to ask you that next. I know you've had the opportunity to practice in front of her. I mean, so far, she seems very measured. She has one of the softest, nicest personalities that I've seen in a judge in a very long time. Tell us about the judge.
You're absolutely right. I mean, I had a pretty serious gang murder in front of her. And yet, even with that happening, she was deliberate, she was quiet, she was polite, she was work person-like. So she was continually grinding through those processes. And that being said, she also doesn't take a lot from a lot of people. So in other words, she very much stands up for herself and does what she says she's going to do. I also think she's learned a lot from Pete Cahill, who was the judge in the Chauvin case. Hence, they put this case in the very same courtroom. We see it's the same courthouse. And I think that institutional knowledge is starting to move from judge to judge. So we're starting to see a piece of that too.
All right, Ann and Michael, I want to bring you into the conversation now and get your thoughts on the process of jury selection and how it's going in that courtroom in Minnesota. Ann, I'll start with you.
Well, we call it jury elimination in a lot of ways, and we used to call it Phil Donahue voir dire out here in Seattle. You kind of go with the whole group and have people bounce ideas off each other, which is great. But it does go really quickly when you have to exercise your strikes, your peremptories, after looking at some of the cause challenges. It's interesting to me that these jurors are feeling negatively about her going into it. I usually see with my jurors in cases where it's been high profile, they've seen it in the paper, that people at least claim to be more neutral coming into the jury selection process. So this bodes, I think, very poorly for her in terms of prospects. I know that they talked about her testifying during jury selection. I'm not sure if I heard that right, but they've raised that with the jurors to see their reactions. And I think that's actually a good idea, to have her testify, but also to test that with the jury.
Yeah, they absolutely did bring that up. You definitely didn't mishear that. They were talking about that. That is a possibility. Michael, I want to get your sense of this type of jury selection process. Do you prefer it? Is it better than another? I mean, let me get your sense.
Yeah, it certainly wouldn't be my preference, but, when you practice in certain courtrooms, you have to go by the judge's rules. But yeah, I prefer the jury selection where I get the large panel and I get to talk to everyone, and then we exercise our peremptory strikes thereafter. Because, sometimes you're not comparing a juror against the almighty, you're comparing them against the alternative. And sometimes you may say, that's not a juror I want, but I'd rather have this juror than that juror. So, I like the opportunity to compare my jurors against the alternatives. And when you're having to exercise that strike after, a single juror, you don't sort of get that opportunity to compare them against some of the alternatives you might receive.
Yeah, we clearly know more information is better, and after doing voir dire of all of them, you have more information, but you do have the juror questionnaires, which helps you along a little bit, but certainly I agree with you in terms of the process. Today, the legal team representing Daunte Wright's family issued a statement which read in part, "This encounter was a pretextual, unnecessary stop of a young black man for nothing more than a minor traffic infraction. States and local governments across the country have acknowledged the need to stop this senseless overreach of police by proposing or putting into law that these low-level matters should not serve as the basis for a stop, arrest, or the engagement of an armed officer. We must look past the shameless victim blaming that has been and will be directed towards Daunte. We must also not be fooled by the defense's cries of an innocent mistake. No reasonable officer can confuse their taser for a gun, particularly a training officer who drew both of those weapons from her duty belt countless times. Daunte Wright should not have been stopped or shot." Jack, let me start with you and get your response to that statement. A couple of really interesting points.
Oh, there's no question about that. I mean, you look at the end of the day, and I understand the argument. And yet at the same time, contemplate it from the officer's perspective. When you stop somebody and you find that there's a bench warrant, It's not as if you get to decide, gosh, maybe I'll arrest them, maybe I won't arrest them. You're going to see from the defense in this case, it's not just about the bench warrant. When he tries to get back in the car and there's an officer half in the car, half out of the car as he's driving away, the question will be, how dangerous is that? Does that rise to the level that an officer has the right to pull not just a taser, but arguably a firearm to stop it? That's part of those pretrial motions. So that's something they're strongly going to argue and say, fundamentally, this was horrifying, terrifying for Kim Potter, and she did what she thought she was doing. She made a huge mistake, but it wasn't a criminal mistake.
All right, guys, stand by. We're going to have to take a quick break right now. We've run over time.